So welcome to today's webinar. I'm Carly from Community Legal Centres Queensland, and today we'll be talking about the RTA's role in managing disputes and ensuring compliance in the rental sector. Before we get started, I would like to welcome and acknowledge the traditional owners of the land on which we're holding this webinar today. In Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people throughout Queensland and possibly Australia, I'd like to also pay my respects to the traditional owners of the land throughout the country and welcome any First Australians joining us today. As I mentioned, today's webinar is on the RTA's role. So with over 1/3 of Queenslanders living in rental accommodation, disputes and compliance issues are likely to arise. So today we've got Lynn Smith from the Residential Tenancies Authority, and she's going to give us an overview of the RTA's services, provide some rental statistics, and look at some of the common tenancy issues that arise, including a really great case example that I've emailed out to you. Lynn's also going to step us through the process for resolving disputes between tenants and landlords or agents and discuss compliance provisions under the Residential Tenancies and Rooming Accommodation Act 2008. So today's webinar will be recorded, and we'll pop the recording up on our website later this afternoon. The PowerPoints have also been uploaded to our website, and a link was emailed out to everyone who was registered yesterday afternoon. If you've newly registered this morning, you can download the PowerPoints from the handout section of the GoToWebinar control panel. We're also going to have a couple of polls today, so make sure you pop in your responses when those polls come up on your screen. That's going to be really helpful for Lynn to know, where you guys are at with your knowledge and the issues that you've experienced or had helped your clients through in terms of tenancy matters. We're going to deal with questions at the end of the webinar, but feel free to pop any questions you have as you think of them in the questions box on the GoToWebinar control panel, and I'll read those out for Lynn at the end. I think that might be everything from me. Just double check. Yes, that is everything I need to deal with. That's fantastic. So I might now hand over to Lynn to start her presentation. Thanks everyone for joining us again, and I hope you enjoyed Lynn's webinar today. Thank you.
Great, thanks Carly, and thank you for the opportunity to speak with you today. My name's Lynn Smith and I'm the Senior Community Education Officer with the RTA. I've been at the RTA for nearly 13 years, and prior to joining the education area, I was a Senior Conciliator in our dispute resolution area. I've been involved with the rental sector for dealing with landlords and tenants for over 30 years. It's an area that I'm quite passionate about, and I'm very happy to be here today and share my knowledge with you. Whoops, that didn't go well. So in today's session, I'll be going through some statistics on the rental sector, the RTA services and what we do, and the volume of work and inquiries that we deal with. I'll be looking at common tenancy queries that we do get at the RTA and the types of disputes, and also advise you on how our dispute resolution process works. I'll also be discussing the role of our investigations area and the types of investigations that we do look into, and at the end, as Carly mentioned, we'll look at doing a Q&A session. So with the rental sector, just to give you an idea, that 34.2% of properties are rented in Queensland, 71.1% of the rental properties are in southeast Queensland, and 96.7% of rentals are houses, flats, units and townhouses. The rest of those percentages would be made up with movable dwelling type properties, and the other parts would be rooming accommodation, so the boarding houses and also the new ones of the purpose-built student type accommodation. So 30% or more of the household income is spent on rent for about 12% of households, and 42% of all households renting privately are families. The fastest growing group of tenants is aged over 55, and the average length of tenancies across Queensland at the moment is sitting at 13.7 months as the average. We do find that this average length is actually higher in houses than what we see in flats and units, and interesting that has actually increased over the past few years and is actually a higher length of months as we go. 43% of tenants have been renting for over 10 years. Now, sorry, I just went back too far, but I might just go back to you, Carly, if that's okay, and we might launch our first poll.
Great. So everyone, you should see that poll come up on your screen now, and I'll just collect responses for about 30 seconds or so. All right, so I might close the poll now and hand back over to Lynn. And
okay, thanks, Carly.
No worries.
Okay. So what does the RTA do? So our core business of the RTA is to administer the Residential Tenancies and Room Accommodation Act 2008 and its regulations. How we do this is by providing tenancy information to everyone that's involved in a tenancy, so no matter whether they're a tenant or a resident or a landlord or an agent. It is a requirement by law that if a bond is paid by a tenant to a lessor or an agent, that's lodged at the RTA, and that's within 10 days of receipt. We do offer a free dispute resolution service where parties in a tenancy cannot resolve their tenancy matters. They can actually apply to the RTA for assistance. We investigate where people have breached the penalty provisions of the legislation. And we provide a range of education across Queensland, including various presentations, webinars and seminars, and also producing digital resources for all clients involved. And we also do provide policy advice to the Minister of Housing and Public Works as well. So as I said, the people that we will help is everyone that's involved in a tenancy, and that is tenants and residents, lessors, agents or property managers, peak industry bodies, and they include like the Real Estate Institute of Queensland, Tenants Queensland and the Property Owners Association of Queensland. We also assist community sector groups and other government agencies. We also, those government agencies will include things like QCAT, Office of Fair Trading, and also Queensland Police Service. So just going back to the poll results, so it does look like 26% of people in today's webinar is dealing with tenancy matters on a daily basis, 21% weekly, and 42% occasionally, and 11% not applicable. So just to give you an idea of the range of people's knowledge in today's session. So the RTA today, what we do is we're currently holding around 600,000 bonds. The value of those bonds is around 842 million. The average value of a bond lodged is $1,400. The average number of calls received is about 1762 per day, and the number of disputes we receive is 107 per day. The website gets just under 10,000 visits per day, and the investigations are just under 4 files that we receive each day, as well as doing the policy and education. So the most common or popular types of inquiries that the RTA receives, a lot of it is in relation to bond inquiries. So about half of our inquiries that come to the RTA are in relation to bond matters. There's also issues around ending a tenancy or inquiries about ending a tenancy and the vacating process, rent and rent arrears, entry to the rental premises, maintenance and repair issues, and also water charging. So I'm going to go into depth on each matter and also give some examples and case studies in resolving some of the issues that we have at these topics. So with the bond types of inquiries, a lessor agent, and yes, even sometimes tenants, can lodge a bond with the RTA by either sending a cheque or a money order by post or online through the website. And they do that with the like a BPay process. There is a time frame as set out under section 116 of the legislation, and that's 10 days to lodge the bond with the RTA. I would say that if the tenant has not received an official receipt from the RTA, say within like 3 weeks of paying it to the landlord, then they should actually make contact with the RTA just to make sure that that bond has actually been lodged with us. A lot of inquiries relate to how to claim a bond at the end of the tenancy. So once the tenancy has ended and there's been a handover of the property, then a party to the bond can submit a refund of rental bond to the RTA. And on the next slide, I'm going to talk a little bit more about bond claims. Some of the inquiries we get are just looking for the progress of a dispute about a bond or just looking for bond information, including bond numbers. It's really important tenants retain their bond number or a client ID because once it has been provided by the RTA, it'll just make things a little bit easier for them when dealing with the RTA. It's very important that the RTA has up-to-date contact details for clients, and if a tenant is vacating or there's been a change in their contact details, that we are informed. So it's a really good tip to make sure tenants do get a receipt when they pay a bond and make sure it is lodged with us, and also make sure that, again, as I said, we have up-to-date details for tenants, particularly if there's a problem about a bond. So just with bond claims, the quickest and easiest way to get a refund is to have everybody involved in the tenancy on the bond, all parties sign and agree refund form and submit it to the RTA. So whether there is a full refund or a part claim, if all the parties, the tenant and the landlord or agent agree, signs the form, submits it online, generally the RTA will refund that bond within 2 to 3 business days. Bonds are refunded into Australian bank accounts, so it's important, again, tenants just double check their details and that make sure that they are correct before they submit that refund form. And as I mentioned earlier, once handover has occurred, where the tenant has vacated or returned possession at the end of the tenancy, a bond refund can be applied for by completing the bond refund form. I always say too, it's a good idea for tenants to ask their agents or landlord about their vacating process and whether they will offer to do a vacate inspection together, particularly on the last day or the next, so that they can actually deal with the bond refund swiftly, and particularly if there's no claims or issues, that can be processed quite smoothly to the RTA. Should the RTA receive a refund form with only one side's signature, we will then write to the other person and ask them whether they agree or they don't agree. This is what we call a notice of claim process and allows the other party 14 days to respond to the claim. That's outlined under section 136 of our Act, but we encourage both agents and landlords to talk with their tenants if there is going to be a claim on the bond, share any of the invoices, photos, documentations or evidence so that the tenants are aware of any claims. The RTA is also taking a bit of a focus at the moment on agents claiming full bonds when they don't require the full bond. So if there's a bond of $1,200 and an agent was claiming $1,200, but in reality they're only looking at $400, well, it's kind of like deemed to be false and misleading claims, and that can lead to our investigations area looking into that. Sometimes we do get agents wanting to refund the bond in full to the tenants, but they don't have their contact details. So again, coming back to the tenants to make sure that they do make contact with the RTA at the end so that we can update their details and put their bank account details in the system to pay their bond out. When it comes to ending a tenancy, it can occur with or without grounds. If it is with grounds, it's outlined in the Act, and it may be because there's been a breach of the agreement that hasn't been rectified. Without grounds means there's no reason, and with general tenancies, the agent or landlord needs to issue 2 months' notice. This could occur towards the end of a fixed term or during a periodic agreement. If the tenant wishes to vacate without grounds, then they need to give 2 weeks' notice. The Act under Section 277 outlines the way how a tenancy can end, and usually it's 7 ways. The tenant gives a Form 13, notice of intention to leave. An agent gives a Form 12, notice to leave. You can have mutual agreement, abandonment, which is the Form 15, a tribunal order, mortgagee in possession, which is Form 19, and also a death of a sole tenant. So notices must be in writing, and the timeframes will depend on the reason for issuing the notice. The RTA's website's listed all the timeframes for both agents and landlords and tenants, so we would welcome you to view those timeframes if you're not sure of something. So ending a fixed term agreement early, or in the sector they call it a lease break, this is an area growing for inquiries and disputes as well. If a tenant is leaving early, they may be responsible for compensation, including loss of rent till a new tenant is found, and or maybe the lessor's reasonable reletting expenses, which could include maybe like a let fee or advertising. When an agent or landlord is claiming compensation, they do have a duty to mitigate loss or minimise the loss, and that's per Section 362. Very important, the mitigation would involve promoting or advertising property promptly to make sure that there's a replacement tenant to take over the tenancy for the tenant vacating. One of the other examples that I can share with you is it could also be that the lessor is wanting to move back into the property themselves or wanting to sell the property to an owner-occupier. The tenant still has a right to the end of the fixed term. However, a lessor may pay compensation or an incentive for the tenant to move out early, and that may be a way of paying costs towards relocation expenses or just a compensation amount. But this has to be, obviously, the tenant needs to mutually agree with the lessor to do this in ending early. It is back to, obviously, a negotiation part between the tenant and the landlord. But as I said before, the tenant does have a right to stay there during a fixed term. In these situations, I would recommend that any agreements are put in writing and make sure it's all signed by all the parties involved. So the tip with all ending a tenancy is make sure that tenants keep evidence and copies of any notices that have been served or have been issued. Take diary notes because it's always a good idea, just in case any matters do escalate, that there's got some evidence there. There may be sometimes some significant reasons why a tenant has to break a tenancy agreement or leave during a fixed term agreement, and that could fall under hardship situations. Following on from ending an agreement early, it may be that the tenant or lessor would suffer excessive hardship if the fixed agreement is not ended. So examples would be loss of income or job, work transfer, health situations, or even divorce. So it's an urgent application directly to QCAT, and that's outlined under Section 415 is the meaning of an urgent application. Should a client, the applicant would need to demonstrate their own case, and at the tribunal, the adjudicator would make a decision if the agreement is terminated or whether it's with or without any further costs. Should a client be experiencing domestic violence, and I'll just quickly touch this, and wishes to terminate the tenancy, if they are talking with the agent or lessor and see whether they will actually mutually agree to end the tenancy. If not, the tenant can apply directly to QCAT on an urgent application. Tenants in this situation obviously may need advocacy support or guidance in their situation, particularly with the application, and also maybe referral to other organisations for additional support. With domestic violence situations, also remember that the Act also does allow for other parts in a domestic violence situation for other situations to occur. So that could be for the tenant to be recognised as the tenant, to remove the name of the person who's committed an act of DV from the agreement. It can be restraining the person who has committed the act from causing further damage or injury, or it could be, as I said before, just ending the agreement altogether. Clients, we would also say to, particularly if people ring the RTA, we also do refer them to organisations like DB Connect for assistance as well. So with the vacating process, this is obviously linked in with the bond side of things, with the bond disputes, but it is an area of concern, and it's really important to make sure that tenants get the paperwork correct in relation, particularly at the start. So under Section 65, the entry condition report, the Act outlines that the landlord or agent will complete, sign and provide a copy of the entry condition report to the tenant. The tenant then has 3 days to go through that report, mark any changes, sign and return a copy. It's best to keep a copy. However, the agent does need to forward a full complete copy to the tenant, but just in case they don't, always good to have a copy on hand. Besides the general tenancy agreement, I would think the entry condition report is one of the most important documents at the start of the tenancy. It's going to outline the condition of the rental property and whether items are clean, working, undamaged. So at the end of the tenancy, the roles are reversed and the tenant has to complete an exit condition report. And that's outlined under Section 66, and provide a copy to the landlord agent. They have 3 business days then to return a copy back to the tenant to their forwarding address. A lot of tenants don't complete the exit report and complete their obligations, and it's so important that they do so because the entry report is compared to the exit report. Section 188(4) under the tenant's obligation state that the tenant is to return the property, return the premises in the same condition it was at the start, less fair wear and tear. Now, the entry condition report is, as I said, compared to the exit report, and it's why important that tenants take the time at the start just to go over the report, make sure it accurately reflects the condition and see if there's any problems that needs to be addressed, and hopefully address it there at the start rather than leaving any issues to the end of the tenancy. What we find, the RTA does actually have a short video on the website for tenants about completing the entry condition report. Remember, it's not just looking around the inside of a property, but checking the outside as well. Photos are a great idea for evidence to support what the entry and also the exit report states, particularly if a matter proceeds to a tribunal about a dispute on the condition of the property. It's great to have those photos. I also think it's a good idea to have tenants just check their rent payments against the agent's or the landlord's rent ledger, just to make sure that it all matches. And as I said before, once handover has occurred, apply to the RTA for a rent refund of the rental bond. Provided no money is owed to the landlord or the agent, the tenant is entitled to receive their bond back in full. So in the rental sector, not all agents, landlords have the same vacating process. So again, communicating just to find out what their process is and see whether or not you can actually do the vacate inspection together and deal with any sort of common issues. Usually one of the questions we are asked when we talk about the tenant leaving the property in the same condition as fair wear and tear is, what is fair wear and tear? And what we find is that it's the normal signs of usage. So it could be like, as an example, minor scuff marks on the walls. It could be deterioration from the environment through sun damage, or just a deterioration over time just because of the age. What I suppose is probably easy is what's not normal wear and tear, and that's usually damage. It could be like holes in walls or the big stains on carpets, and possibly like even cleaning issues. So the tip is to obviously take photos, keep copies of the reports, but definitely those photos is really, really important. In relation to rent payments and rent arrears, Section 83(7) of the Act talks about how and when rent is to be paid, choices of approved ways under the Act, and also rent in advance. It's also important to note that, like, if rent is paid in cash, the Act states that the landlord or agent must give a receipt. If it's done by if it's done by cheque or a bank transfer, then the lessor or the agent only needs to provide a receipt if the tenant requests it. So the tenants are due to pay rent, obviously, when rent is due, but the landlord cannot ask for a tenant to pay for a period of rent that has already been covered. So we know that sometimes there's a bit of confusion about payments of rent in advance, but again, if rent has been paid for a period of time, then the landlord cannot ask for rent to be paid again during that time. So to step through a breach process if the tenant does not pay rent. For general tenancies, the tenant needs to have fallen 7 days behind in rent. On the 8th day, the landlord or agent can issue a breach notice, a Form 11, notice to remedy breach, and giving a minimum of 7 days to rectify that breach. So if the tenant doesn't rectify, then the agent or the landlord is in a position to issue a notice to leave. But for room accommodation, if a resident has been residing there over 28 days, they're 2 days behind, then the residents can be given 4 days to rectify that breach. So while it is the tenant's responsibility to pay rent, as I said before, when it's due, sometimes, let's face it, things happen in people's lives. We again say communication is key, and we recommend that if there's difficulties for tenants to talk with the landlords or agents and see whether they would be willing to allow a short period to catch up or enter into a payment plan. We note that that is obviously up to the landlord agent whether they would accept this, but any agreement would be recommended to be put in writing. So if there's a problem with repairs, sometimes we hear tenants say to us, I'm going to withhold rent. Obviously, we would not advise that. Rent is rent, repairs are repairs, and I will talk about repairs shortly. So we wouldn't recommend tenants withholding rent in those situations. During the tenancy, there may be a case of the landlord or agent wanting to enter the property. The rules for entry are explained under sections 192 to 199, and the reasons for entry may be for like a routine inspection, carry out repairs or checking smoke alarms or safety switches, or showing prospective tenant through the property. If the tenant's been issued a breach notice for a significant breach of the property, then the agent can issue an entry notice to re-inspect and check that the breach has been rectified. To do that process, it is 24 hours notice and must occur within 14 days of the breach expiring. So to give you an example of a significant breach in these situations, using the premises for illegal purposes, exceeding the number of occupants allowed to live there, keeping a pet without permission, and any other matter that may exceed 1 week's rent to rectify. What we find with agents doing inspections, we always say, look, at the end of the day, there is significant breach. This is what the rules are around that, but what's not a significant breach is if someone hasn't done their dishes and it's sitting up in the kitchen sink, or if the washing's piled up in the laundry. Clearly, nowhere near being a significant breach. The agent or landlord needs to issue that Form 9 and comply with the timeframes to enter. If the tenant has concerns about entry, they should communicate with the agent or the landlord and maybe look to reschedule another time. One of the questions that we are asked by tenants is, if I'm not at home, can the agent still enter? The answer is probably yes, but they make sure that the agent has followed the rules that's under the legislation, and that they have given the correct notice and the reasons why they're entering has been outlined. And if that be the case, they can enter. But agents should also to remember that, you know, while it's the owner's property, it is still also the tenant's home. So there are rules also around the times that an agent or landlord can enter, and they cannot enter outside the times of 8 a.m. to 6 p.m. on a Sunday or public holiday, and also too, unless the tenant agrees, is when they can enter on those occasions. So if there's to be an open house for sale or for relenting, the tenant has to give permission for that to occur, and that's also an area that we are finding in our investigations area, that agents are looking to try and do open houses without the tenant's written permission. Okay, so with maintenance, again, another area growing with inquiries and also leading into disputes where repairs and maintenance are not being done. So under the Act, the landlord's obligations are outlined under Section 185, and that is the lessor is to make sure at the start of the tenancy, ensure the premises and inclusions are clean, fit to live in, good repair, and not in breach of any health or safety issues. But that section also then further continues to say that while the tenancy continues, the lessor must maintain the premises and inclusions in good repair. So the tenant does also have obligations, obviously not to, under Section 188, not to maliciously damage the property, but they also do have an obligation to inform the lessor about any repairs or routine repairs that needs to be done to the property. So while the Act doesn't state that, it says that notice must be given to the lessor, well, it states that, what that notice is, most tenants would inform their landlord or agent by phone or an email, or in some cases, we know agents say, look, we have a maintenance request process to fill that in. But the tenant can also issue a remedy breach notice, and more so this is effective, particularly when the agent or landlord has not carried out the repair that they've requested. So Section 214 talks about the meaning of an emergency repair, and it outlines an emergency repair such as like burst water systems, serious leaks, dangerous electrical, gas or electrical faults, flooding, storm. It's really coming down to a fault or damage that makes the premises unsafe or insecure. Everything else would probably fall outside that and into the routine repair side of things. Form 11, the remedy breach notice process, is available to tenants, and if a landlord is not doing a repair, then we encourage tenants to make sure that they do complete that remedy breach process. Communication is encouraged with agents and landlords, particularly if they've got delays in doing some of the repairs, and some of the cases that we see come in, and particularly when summer occurs, is air conditioners not working. And sometimes it may take 6-7 weeks or so to get parts to come in. If the item is not working or part of the property has been not available to the tenant would be entitled to receive a rent reduction or a compensation during this time. What that amount may be is really depending on the situation. To give you an idea, things that might come into play is like for air conditioners not working, or what would the property rent for if it was working versus not working, if a room was affected or whether the whole property is affected. I have seen cases in our dispute area where the amount could be $20 a week, $50 a week, but again, a lot of these compensation cases or rent reductions are done on a case-by-case basis. So if a tenant cannot get repairs done, the option is available, and we welcome them to come through our dispute resolution process for assistance. Just to give you a story as well, on one of the disputes was we had a tenant that had a stove wasn't working, and although a stove is deemed to be an emergency repair, the tenant came to us just seeking compensation of $30 a week for the stove not working. How he worked it out was that he said, look, realistically, I was going to the buy a cheap meal Monday to Friday at $6, times that out, and it worked out that he was looking for $240 because it was 8 weeks that the stove wasn't working. When it came through our dispute process, the claim, was obviously thought to be quite reasonable, and the tenant showed it and how he had actually justified the amount that he was claiming. The owner refused to pay and said it wasn't her fault that there was delays, and so the tenant did take it to the tribunal. In the end, the tenant did receive a higher amount of compensation, which was, I believe that he might have been offered more, but in the end he ended up taking a compensation amount of $640. So it's really important to keep diary notes of conversations, copies of breach notices issued. If you can't resolve the matter directly, come through our dispute process for assistance. As I said, while we recommend self-resolution, some matters cannot be resolved and does require a third party to be involved to try and get it sorted. In relation to water charging, the Act does allow for water to be passed on to tenants, and that's only when the property is individually metered. The agreement provides that the tenant will pay for water and that the property is water efficient. What we ask is that water bills are passed on to tenants in a reasonable time frame, and that's an area that is concerned in the sector where landlords are holding on to water bills and just charging the tenants all at the end of the tenancy rather than passing them on as they come through. The tenant does have 1 month to pay the water bill, and keep in mind that the water bills and the leases don't necessarily align up. So in relation to if the property is not water efficient, then it may be that the lessor pays a reasonable amount and the balance is for the tenant to pay. We have seen some evidence coming through with our dispute area. One of the more initiative parts of evidence, I suppose, we've seen is where a tenant has collected water in buckets in relation with a stop clock and showing how much water flow was to show that it wasn't water efficient and didn't meet the requirements for the water flow as per so many litres per minute. So he took it to the extreme and had a video to prove his evidence of why when the property wasn't water efficient when the landlord had said it was. So if a tenant does dispute the property is water efficient, then they should probably go and ask the landlord or the agent to provide evidence as such that the property is water efficient. So I believe it's over to you, Carly. We're just going to offer another poll question.
Excellent. So everyone, you should see that poll come up on your screen, and I apologise, I should have done this before. I'll read the poll out in case you have problems seeing that. So if you've assisted a client with resolving a dispute, what was the matter about? A, ending a tenancy, B, bond money, C, an issue during the tenancy, or D, not applicable. So I'll just give you another 30 seconds or so to enter your responses, and then we can share those results with you. So just another 5 or so seconds and then I'll close the poll. Thanks everyone for participating. All right, I'll just close that up now. So Lynn, would you like me to read out the results of the poll?
That would be great. Thanks, Carly.
No worries. So we've got 35% ending a tenancy, 25% about bond money, another 25% about an issue during the tenancy, and 15% not applicable.
Great. Thanks, Carly. Okay, so we'll just continue through with the dispute resolution side of things for the RTA. So last financial year, just to give you an idea, the RTA received over 27,000 disputes across Queensland. Of these matters, the RTA resolved 78% of them when the parties actually participate with the process with us. We do see dispute resolution as like a 3-step process in resolving tenancy matters. First of all, encouraging self-resolution. So asking questions, getting information. Obviously, communication is key to resolving the disputes. Although we know in disputes there is a high level of emotion, it's obviously best to stick to the facts. Consider whether there's any negotiation or any compromise. Listen and be respectful to see what the other and see what other options might be available. As I said, communication is a key to resolving a lot of the issues. If it's not resolved between the tenant and the landlord agent, tenants can apply for the RTA's free dispute resolution service. If it's still not resolved, then the matter then can progress through to the tribunal, and that's an application then for adjudication. Under Section 415 of the legislation outlines what an urgent application is, and that will fall into usually matters where the tenancy is where the tenant is still in the property, we find. For a lot of non-urgent matters, you do need to come through dispute resolution, and that usually involves like a money compensation or a bond matter, and that has to go through dispute resolution first. So to access our disputes process, first of all, need to complete a Form 16 to start that process. Contact details, provide a brief outline. Look, 1 page is fine. We don't necessarily need a novel to be attached to the dispute to actually start it. We just need enough information to get the dispute going. For bond disputes, we ask that the landlord or agent who's claiming those parts of the bond to give us a breakdown of the claim. We also ask them to share their information, like invoices or photos, directly to the tenants, just before we actually are going to progress the matter through conciliation. So if a dispute is over a notice received or an issue that's happened, then attach a copy of the notice. This is B, where potentially a tenant has received a breach notice or has issued a breach to get something repaired, or received one that they dispute. It could also be that they're seeking for compensation for, as I said before, the rent reduction in the repairs situation. There's a lot of information on our website about the dispute process, and at the moment our dispute requests are taking, from the time received to when they're actually through the process, is about 21 days. So the types of common disputes that we receive, look, the RTA receives about 50% of the disputes are bond-related matters. 17% of the files we receive are for compensation. So this is where money is owed over and above the bond amount, and the landlord's seeking the excess of the bond. Non-lodgement of bond, this is also an offence under our Act, but if a bond hasn't been lodged by the lessor and the tenant and the landlord is not returning the money, the tenant will need to lodge a dispute request with us. If it's not resolved, obviously take the matter to the tribunal to seek that money. But as I said before, it's non-lodgement of bond with us is an offence under the Act, and I'm going to talk a little bit more about investigations shortly. With tenancy matters, we receive disputes on repairs, ending a tenancy, rent arrears, and it also too might be in relation to disputes about entry. With some of the disputes, tenants may be given access when the notices are not compliant with the legislation, or where a tenant may feel that the agent or selling agent is interfering with their reasonable comfort and privacy of the property and issuing excessive notices for inspections. So again, some of those sort of scenarios are quite common through our dispute area. With our intake, what we do is we need to assess the dispute that comes through. So during the assessment, we need to make sure that it is actually covered by the RTA first. Surprisingly, we do actually receive disputes coming through where the disputes are between neighbours or about a neighbourhood dispute, and clearly that's not, the RTA cannot assist that. So the RTA will list on our website all the matters that are not suitable for conciliation. So if it is suitable, then it proceeds off to the telephone conference. If it's not suitable, it could either be file will be closed, or it could be that we will issue a notice of unresolved dispute. And those notice of unresolved disputes are very much time sensitive. So if it's a bond matter, there's a 7-day time frame for tenants to apply to the tribunal and inform the RTA. If it's a tenancy matter for compensation, then potentially looking at a 6-month time frame to lodge the application from when you're aware of the event or the breach. So with the dispute, as I said, assessing the file, we're going to be looking at the number of parties, the complexity and the types of the issues that's been stated in the dispute, whether it's minor or trivial matters, and the level of contact, level of conflict that's in that dispute. We also need to see whether the client is willing to engage with us in the process. The conciliation process is a voluntary one, so if the party is not willing to engage with us, we cannot force that to happen, even though we encourage it. But as I said, if they're not willing to engage, then we may need to close the file. We're looking at contact details. So again, very important that tenants always make sure that we have their full details, the availability of parties, and if so too, if there's been previous disputes on the matter or it's a new matter that's been involved. The conciliation process, we do have a flowchart available on our website for our dispute process, and that also, as I said before, does include matters that are unsuitable. So with the telephone conference, it's booked at a date and time, and it's dealt with, or we could actually deal with it via what we call a shuttle negotiation process, where we would make separate calls to each party to try and resolve the dispute. The ownership of the dispute is actually by the parties involved, so they take full ownership of the outcomes. Clients can have a support person. I think that's very important for you to probably understand that, that if they do need someone to be there with them through this process, that is available. And also too, we do have access to the interpreter service. We encourage agents to make sure that all that paperwork about any bond claims is actually given to tenants prior to the conferencing. But again, it doesn't stop, just because the dispute has been lodged with the RTA, it doesn't stop tenants and landlords and agents talking to each other, and we would still recommend, obviously, keep those lines of communication open if we can. The role of the conciliator is impartial, so they're not there to take sides nor make decisions. It is a confidential and voluntary process, so anything that's been said in the dispute process, if the matter does proceed to the tribunal, you do have to start again and disregard any of the negotiations in the conciliation process. The role of the conciliator is to encourage the settlement of a dispute. So we do that through facilitating and helping conduct negotiations, promote the exchange of information, and provide information on the operation of the Act. Part of the process we also do is like reality testing the strength of the dispute against the legislation, and also unrealistic claims or unsubstantiated claims. So at the end, the matter will either be resolved or unresolved. So if it's a bond matter, all parties will need to sign a refund form, and then the RTA will process that refund form and pay out the bond accordingly. If it's a tenancy matter, a conciliation agreement will be drawn up, and again needs to be signed by all parties involved. The conciliation agreement then may form part of the tenancy agreement, and then the matter is all finalised. But if it's unresolved, we issue what we call a notice of unresolved dispute to the person who has lodged the dispute request. It is a non-urgent matter that needs to apply to the tribunal, to QCAT, with bond timeframes. So if the matter is relating to bond money and the person is issued a notice of unresolved dispute, they have a 7-day timeframe to lodge the bond at with the tribunal, get a receipt from the tribunal, and send those details in writing to the RTA within that time frame. So it is a two-part process, and it's so important that not just lodging, but making sure that the RTA is informed, particularly on those bond disputes. For tenancy matters, it's 6 months from when they are aware of the breach or the event. So applying to QCAT probably goes beyond the role of the RTA as such, but QCAT does have a checklist on their website, and I would recommend anyone assisting a tenant to go off to the tribunal to actually look at that checklist. The application form needs to be fully completed. There needs to be the appropriate number of copies and a filing fee, and attaching all the relevant information like tenancy paperwork, notices, photos, diary notes. As I said, QCAT's website does have a lot of information, and again, I just remind people with bond matters, it's so important that, again, not just lodge within the time frame of the notice, but also to inform the RTA of the application that's been made. If we don't receive notification that someone has taken the matter to the tribunal, the RTA is going to pay out as per the first refund form that we have processed. So if someone has lodged a claim and the other person disputed, but then didn't take it if it's not resolved and they don't take it further, then and we don't get notified, we will pay the bond out. So with investigations, and I'm a little bit conscious of time, so we make sure that we can get to your questions. In relation to investigations, to give you an idea, there's a difference between disputes and investigations. So disputes are more about relating to a tenancy matter between the agent or landlord and tenant. Could be about bond refund or a breach of a tenancy agreement, either the standard or special terms. Either party then, if it goes through our dispute resolution process, if it's not resolved, it's through QCAT. It's self-representation in front of an adjudicator or qualified JPs. With the second box that I've got there, the investigations look at the alleged breaches of the penalty provisions of the Act. So out of the 568 sections of the Act, there's about 125 sections that have penalty provisions attached. And it's those breach of those provisions that we can actually, our investigations area can take the matter further and take it to the magistrate's court. So it's not QCAT, and this is where it actually involves like legal representation. So our investigations unit, the purpose is to empower people to understand the rental market regulations, and the function is to ensure the compliance amongst Queensland about the tenancy rules. And as I said before, there's 125 penalty offences under the Residential Tenancies and Room Accommodation Act. Our investigations team last year finalised 815 cases, and as we look at the previous history of that, I think the previous year was about 690, and before that was 543. So it has actually been a significant increase. We do have reactive and proactive cases. So reactive cases is obviously when a complaint has come through, maybe an internal referral from our call centre, and proactive is maybe where we've actually gone out, we've been shared intelligence or some information, and we actually go and make a proactive case from that. We do receive referrals from other agencies like Office of Fair Trading, that's dealing with a lot of real estate agents, and particularly like with trust accounting and things like that, Queensland Police, and also Queensland Fire and Emergency Services. It's important to note that there is a 2-year time frame here from the offence date to deal with the matter through the investigations and prosecution process. So it's important that if a tenant is aware of a breach of the Act, that they do something straight away rather than wait. So it's best that if we can potentially get information about the complaint within the first 12 months, then we still have a time frame if the matter leads to a prosecution that we can actually finalise the matter within that 2-year time frame. So Carly had sent out a link, and if Carly could send the link again as well to a story that we shared on our website. So we had a recent prosecution of a Brisbane real estate agency. It was 3 accounts of unlawful entry, 1 account of unlawful special terms. The total fine was $10,000 to the agency, and plus a conviction was recorded against the company as well. We have had some other recent cases, and one of them was up in North Queensland on an agency at the end of March, where they were fined $8,500 for 6 unlawful special terms and 1 count of unlawful entry. So as you can see, our investigations area is very interested in insurance compliance in the rental sector. So again, we want to make sure that we know those situations and that we can actually deal with it. The most common types of investigations, I'll just quickly go through: the non-lodgement of a rental bond or the late lodgements. As I said, the agents and landlords have 10 days to lodge the bond to the RTA. Unlawful entry, unlawful recovery of possession of the property. Contracting outside the legislation, and this is special terms, and what we are seeing is clauses where tenants have been required to purchase a particular service or required to do professional cleaning at the property at the end of tenancy. So this would be breach of Section 171 and also contracting out of the Act of Section 53, where it states that the tenant is to return the premises in the same condition, less severe wear and tear, and that the tenant is not required to purchase a particular service or goods as part of their tenancy. One of the other areas that we're seeing is photos used in advertising without written permission, or conducting the open house without written permission, and not having the agreement and the entry condition report at the for the whole of the tenancy, or not giving a copy to the tenants as well. The types of actions that can occur: if substantiated, the complaint is substantiated, the RTA can provide education. We can issue a warning letter. We can issue a penalty infringement notice, which is a percentage value of what we potentially might have got if we had taken the matter through to the for a full prosecution, or we can commence prosecution. And as I said, that's where it's a little bit more legal and requires a little bit more processing from the RTA's point of view. So with the complaint process, contact the RTA for what we call an investigations request form. Provide the evidence and information and submit that to the RTA. The investigators will most likely look at seeking further information, particularly if it's not clear. And depending on the matter, particularly if it's going through the penalty infringement process, or if it's going through the prosecution stage, they may also ask for a witness statement to be completed by the complainant. So we're encouraging tenants or people even supporting clients in the rental sector that if there's a breach of the Act, consider lodging that complaint. There's a high level of focus on compliance at the moment, and we also want to make sure that we find the people who are not doing the right thing. So I guess, and I'm very conscious of time so that we can actually get to the questions too, Carly. So I guess my overall tips are, look, tenants keeping records, and that may include just diary notes of things, of conversations, ensuring the paperwork's right at the start, taking photos, and if there is problems, remember that we are here to help, and we do have that free RTA dispute resolution service available. Ensure the tenants are actually providing the RTA with the up-to-date contact details, and particularly at the end about their bond, making sure that they lodge those refund forms with us with their bank account details on the form. And more importantly, if there's a breach of the legislation by an agent or a landlord, tenants can contact us to discuss it and look at potentially lodging a complaint. We have a lot of information on our website, including videos, publications, fact sheets and forms. We are here to help, and we want to make sure that, one of our sayings is that making sure that renting works for everyone. So I'm going to go over to you, Carly, for any questions.
Excellent. Thanks so much, Lynn. There was a lot to get through there, and so I hope
a lot of content.
Yeah, but really good for our people to know, I think. So a couple of questions have come through, so I'll just read those ones out for you. So the first one is from Alan. Can the agent charge advertising costs in a break lease situation?
Alan, they could charge advertising in a break lease. It's about reimbursing the lessor, I suppose, for reasonable reletting expenses. And it's that word reasonable that comes into play. We know that in some situations, some tenants take it on board themselves to do their own advertising, just to try and mitigate that loss in trying to find a replacement tenant as soon as possible. So they could be charged advertising. It's such a vast area out there at the moment, because some agents will just charge maybe a reletting fee of, usually it's 1 week's rent plus GST. Some charge a portion of that, some charge that plus advertising, and some will just charge advertising. But it is about reimbursing the lessor's reasonable expenses in reletting the property.
Fantastic, thank you. So I've got another question here. Are there rules for when a landlord has solar installed and would lose rebates if the account changed to the tenant's name? And what can the landlord on charge to the tenant? That's also from Alan. Thanks, Alan.
Alan, you're very busy this morning. Thank you for the question. Solar is one of the areas that we are seeing some inquiries about. The rebate is actually dealt with under the Department of Energy and Water Supplies, so not actually really our laws as such. But one of the things that we do know with solar rebates is that most landlords, if they've paid out that money to get the solar system on the property, what they're looking to do is obviously recoup that, and they may try and keep the account in their name. And under the dues, the Electricity Act, it talks about that the person who gets the rebate has to have the name of the account in their name. What we have seen happen, there's a few different examples come through. The landlord keeps the rebate in their name. They have an option of either forwarding on the account to the tenant as a full account. They could forward on to the tenant as a rebated amount, so they may offer a portion of the rebate or a fully rebated account to the tenant. It's not actually very clear, but what we do say is that any negotiations about solar, particularly with electricity, is actually worked out front. It's also advertised up front and be very clear, so there's no confusion for tenants. Who gets the rebate? Is there a portion? Is it negotiated? It could be that sometimes tenants do, the owners will actually allow the tenants to put it in their name for the electricity, and that's fine because obviously then the tenant gets the rebate. But the other part that comes into play is that some landlords are also going, you know what, I don't want to have any issues in relation to what rebate goes where or whatever. Rent is actually the rent is a higher rent, and it actually includes electricity. So there is some options for landlords and tenants obviously to negotiate, but our main thing with this is for making sure that whatever is agreed is actually in the tenancy agreement, and be very clear up front who's getting the rebate. Is it a full amount going to the tenant? Is it a rebated amount? How it is actually worked out.
Okay, fantastic. Thanks, Lynn. I've just got a couple of questions here from Julie at Women's Legal Service. So, how long on average does it take to resolve matters through the RTA dispute resolution and mediation process? They've heard it can be anywhere between 4 to 8 weeks. Is that your experience too, Lynn?
Julie, that is a good question, and I can probably say to you it really depends sometimes on the time of the year as well. At the moment, I know that from when a file is received, currently we are sitting at around 3 weeks before it is actually through the intake and conciliation process. So at times, and we do know at the beginning part of the year, we are very busy because the sector is very busy. When people move in and out of properties, it just means that our bond area gets busy, then our dispute area gets busy, and so on. So potentially it can be, on average, probably around 4 to 5 weeks. So that would be about right.
Okay, and just another one from Julie. As a tenant, can you access the evidence that the RTA mediator has received from the real estate agent?
Julie, it really comes down to if it's in relation to like a bond claim, we would be encouraging, like if the agent has provided us with invoices, photos and things like that, in most situations we would be, if the agent is not passing that on to the tenant, we would probably pass it on. In relation to some of the other issues that might be requested, it really might come down to some privacy laws, what we may or may not be able to pass on. But if the aim of the dispute is, if the agent is saying to us, we have a list of the claim here being carpet cleaning or general cleaning or 5 days rent and there's a ledger and things like that attached, well, we would think that would be in the best interest to share that with the tenants, so that they are aware of what the claim is so that they can have a look at the information. But again, it's encouraging the exchange of that information. Some, as I said before, it depends on what it is. If it is in relation to some privacy issues, then that might then needs to, may not actually happen. But also too, there is a, for any information, there's obviously the right to information process, but again, in dispute, we would be wanting to encourage the exchange of information to resolve that matter.
Okay, wonderful. So I've just got, I think that might be all the questions from the group now. I've just got another couple of questions here though, if you could respond. I know that we're a little bit over time, so thanks everyone for sticking around. If you do have to leave, this part will be recorded so you can always catch up later. So Lynn, can you please just explain the repeated breaches process?
Sure, Carly. With repeated breaches, the Act outlines that if a party, so either a tenant or a landlord, breaches the agreement twice in a 12-month period, on the third occasion within that 12-month period, should there be a further breach, the other part, the landlord or the tenant, whoever's the other side, can actually apply to the tribunal for a termination order on the grounds of repeated breaches. I think that's section 299 for if a landlord's going down that path. However, there are rules around that in relation to that each breach has to be for the same breach. So, and it also has to be rectified each time. So each breach, same type of breach, each breach has been rectified within the required time frame. On the third occasion that there is a breach, then you can apply to the tribunal. With repeated breaches, obviously we're looking at that they do need to be significant in relation to terminating the tenancy. What we do find with agents and landlords going down this path, some of them may actually give a third or fourth opportunity, but this usually happens with rent arrears or things like quiet enjoyment, where people are a little bit party animals and there's continual disturbances in the neighbourhood. So that may actually also be an example of repeated breaches.
All right, wonderful. Another couple of questions, if you don't mind, Lynn. So if a tenant receives a notice to leave, can the RTA intervene and stop the eviction?
We can intervene as such, however, we cannot override that notice to leave if it's been served, and at the end of the day there's a process that the Act allows, and that is that if the notice to leave has been issued according to the laws, legislation, then they can look at potentially taking the matter further and taking the issue to the tribunal for termination and a warrant of possession. However, if a tenant does receive a notice to leave, and they feel that it's not warranted or it's not been served correctly or anything like that, we would welcome them to contact the RTA, and we would step through what options are available. And as I said, even though we could make contact with the other party, with the landlord or the agent, to discuss the notice, we don't have the authority as such to overturn that notice. We may discuss it with the landlord or agent, and then they may find that their timing might be out, and reality tests that, like, if you take this to the tribunal, they may look at you haven't served the notices correctly, things like that, but we don't have the powers as such to overturn a notice to leave. But we will certainly discuss it with parties if need be.
Okay, sure, thank you. Penny's just sent through a question here. So, can we have access to the decisions where the penalties were applied as a result of your investigations? Are they publicly available decisions?
That is a fantastic question, Penny, and probably one that I might have to get back to you, Carly. I would have think with all court cases, because it does go through the magistrate's court, that information obviously may be available through their channels after it goes through their official processes and everything. But definitely, probably I would need to get back to you in relation to that, Carly.
Yep, that's not a problem. I'll send you the details, and we can certainly get back in touch with Penny once you've had a chance to look into that for us. The last question, just one last question for the day. So, can you explain the abandonment process?
Sure. With abandonment, the Act allows that if a landlord or agent believes on reasonable grounds that the tenant has abandoned the property, that they can enter the property. So usually if they've got signs of, the mail's overflowing, or the neighbours have mentioned that the tenant moved out and things like that, that the agent can, or landlord can enter with a Form 9 entry notice to the property and enter to see whether the property has been abandoned. So that would be probably the first step. Second step when they get there is that if they feel that the property has been abandoned, they have two options. They can either issue a Form 15, an abandonment notice, given 7 days notice to end the tenancy, or they can apply to the tribunal on an urgent application on the grounds of abandonment to terminate the tenancy. They're all options that are available. However, if during those processes the tenant does come back through and finds that they haven't actually abandoned, there's a process that, and it's very clear on our website too, of what they can actually do in putting an application in to the tribunal that the property wasn't abandoned. So it is quite tricky, and we always recommend to, particularly like if agents are going down this path, to make sure that they have very clear evidence that the property is abandoned.
All right, fantastic. I think that's probably enough tricky questions thrown at your direction, Lynn. So thank you so much, and on behalf of everyone clapping and cheering at their computer screens, it's been a pleasure to have you here today. I will put the recording up online for everyone to view later if you need, together with the PowerPoints and a link to the case, which was also sent out in the chat box during today's session. And also, if you could please complete the SurveyMonkey and provide some feedback on today's webinar, that would be fantastic. Thanks so much, Lynn, and we'll see everyone next time.
Great.